Female professionals, not being employees, are not entitled to maternity benefit, Delhi High Court. In its judgment in the case of Delhi State Legal Services Authority (DSLS), A/They/2951/2024, the Delhi High Court held that a female advocate appointed in a professional capacity in an organization is not entitled to maternity benefits in the absence of an employer-employee relationship. Factual background: the respondent was appointed as an advocate in 2016, for 3 years, as a panel lawyer LSA, with the Delhi State Legal Services Authority. In 2017, she applied for maternity leave for 7 months, but her request was denied by DSLS, citing the absence of provisions for granting such benefits to LSAs. The issue that, therefore, came to be presented before the division bench of the Delhi High Court was whether the maternity benefit under the Act is available to professionals such as the respondent, being engaged as a consultant and not an employee. It was contended that the remuneration received by the respondent did not fulfill the criteria of wages under the Act. In a scenario where an advocate provides services to multiple entities, the question arises as to which entity is responsible for providing maternity benefits as mandated by the Act. Key takeaways from the ruling. The following are a few important observations made by the High Court that laid the foundation for its decision. Existence of employer-employee relationship a must. The court concluded that the benefits provided under the Act are exclusively applicable to a woman employed within an establishment under the control of the employer who is paying wages to her. Key takeaways from the ruling. The distinction between wages and honorarium. The court relied upon the Supreme Court's interpretation of honorarium in Kabhari Bhimaji versus Shankar Rao 1975, to mean payment made other than salary. In the present case, the payment made to the respondent was in the form of an honorarium, as opposed to wages paid to an employee for regular work. Notably, in the present scenario, if the respondent did not render services on a given day, the corresponding fees would not be paid. Hence, the engagement of the respondent was irregular, diverging from the predictable nature of typical employment arrangements. Any question, ask C-Quel.